So good evening, everyone. On behalf of Ahmedabad Management Association and Gazia, I welcome you all. It's a true honor to stand before you today and embark a discussion about remarkable journey we have undertaken in the realm of technological advancements. In this ever-evolving landscape, computer-related inventions, fondly known as CRIs, have emerged as a pivotal player, shaping the way we live, work, innovate, and execute. Over the past 2 decades, information technology has transformed into a crucial tool for scientific progress, covering the entire spectrum of data, handling through computers, networks, hardware, softwares, and telecommunication equipments. The advent of Industry 4.0 marked a revolutionary shift way back in 2011, integrating the Internet of Things, which emerged in 1999. Then came cloud computing, then came cyber physical systems, cognitive computing. All of them put together, they brought advances into manufacturing and services environments. This transformative era brought about in automation, connectivity, and the application of algorithm translating the digital decisions into tangible changes. As we step into Industry 5.0 now, our focus shifts towards collaboration between humans and machine, completely new way to look into the technology now, emphasizing personalization, resilience, and a human-centric approach and sustainability. In this all, we have now almost into the digitized world. The information seamlessly flows. It flows through different technologies and telecommunication devices. And not only that, what we have received as an outcome through digitization, what has fostered by democratizing access to information and opportunities is equality in true sense. So the law and constitution is really happy because the equality has brought and it has reached to the lowest strata of the society. The online educations, e-government services, medical offerings from the government, financial inclusion, online payments, all of this have brought together and made the citizens in the equal format. As we navigate through these digitized landscapes, challenges inevitably surface, striking a balance between a legal balance between technological advancement and the protection of intellectual property rights become really crucial now. It is through this equilibrium we're going to motivate the innovators to produce better, novel products and services so that reaping the fruits of their innovative efforts to the society. This symbiotic relationship will foster an environment which progress and creativity can flourish. In India, we have witnessed a significant shift from filing of inventions and patents in this sector, that is telecommunication, computer-related inventions, and electrical. When they all put together, the number is much, much higher compared to all other segments of sciences, which is a great shift. And if India stands on 40th rank of Global Innovation Index, then the contribution from ICT industry is nothing short of incredibility. In this dynamic realm of innovation, numerous visionaries collaborate to bring forth novel products and services. Here comes the role of patent law, which serves to safeguard the innovators by providing them monopolistic rights. This robust framework encourages risk-taking in turn and inventive thinking too. And it fosters an inclusive environment for groundbreaking solutions. As we stand at the cusp of an era which is defined by collaboration, innovation, inclusivity, I would urge everyone present here to embrace the opportunity that is lying ahead. Together we can really tap unexplored opportunity by patent filing, protection into businesses, and we can even contribute into the nation building. To shed more light on these nuances of computer-related inventions, it's my utmost pleasure to invite our revered speaker, Mr. Greg, to share his insight. Please join me in welcoming him warmly. Mr. Greg Maurer is a partner at Carlquist Smartman LLP in Portland, USA. He specializes in computer-related and bioinformatics patent applications, open source software, and intellectual properties counseling. With expertise in software development, big data, bioinformatics, and telecommunication, he has experience in complex algorithms and various programming languages. Emphasis on communicating with inventors to capture their inventions and working with in-house counsel to focus efforts on business goals. He also enjoys presenting patent topics to non-patent and non-legal audience, and that too in a very, very effective manner. Ahmedabad has already witnessed a few of them earlier. Some work in litigation support, trademark protection too. And his specialties are complex software applications. The unit of patent office that does bioinformatics application is completely different from regular software group, and he enjoys being expert in that domain. Over to you, Greg. And before start your presentation, I'd like to welcome you with a token of appreciation. So, over to you, Greg.
I'll go down here and walk around as usual. Put that in the pocket or something. Okay. All right, everybody. Thank you for coming today. I want to thank the association for inviting me, making this connection happen. I'm a software patent attorney. It's a very strange animal, right? I mean, there's not a lot of us around, but we are very busy right now. As was rightly said, there's a huge increase, and we'll get into that. Now, the topic that I'm putting on today has to do with infringement of artificial intelligence patents. It's even narrower than being a software patent, so it's a very narrow topic. Having said that, if you have anything that you want to ask about anything, even if it's about trademarks or whatever, please ask. Okay, that's why we're here, to exchange the information. And you might think that, you're getting the benefit because I'm giving you the answer, but actually I'm getting the benefit because you're giving me the question. This really is what I need. I need to know what people are interested in, okay? And so I'm very surprised at what people have to say, and there are some very intelligent questions that come from this group, so I encourage you to ask questions. So this presentation is licensed under Creative Commons. I would be happy for you to make copies. I doubt you will want to make any copies, but if you do, you can make copies, okay? So we'll talk a little bit about what is an AI, what is patent infringement, and then special infringement considerations in that AI context, and then we'll look at a case study. And then I also have some practitioner profiles, so you can see people in our office, what are they doing on a daily basis and using ChatGPT and things like that. So there's some other things to think about. Can an AI infringe? Can an AI police? Can an AI decide legal issues? And the theme I have for today is that, okay, I come all the way from the United States to talk about this, and patent offices around the world struggle with whether or not to allow patents on computer-related inventions. Of course, you can't get a patent on software, per se. We all know that. But Microsoft gets thousands of patents every year. SAP gets thousands of patents. Amazon has thousands of patents. Google, thousands of patents. So you can get the patent covering the computer-related invention. The question is, what do we want to do in our law to encourage patenting? And it can be very complicated. The United States Patent and Trademark Office has decided to encourage certain kinds of AIs that can be patented and others not. And you'll see actually in the US focusing on training, which as a patent attorney I don't like, because The training might be done in one room, and then the use might be done in another room. But this is what the USPTO has decided. India may decide the same thing. India may decide something different. So it's just something to think about. Somebody here, you know, ever has an opportunity to influence a lawmaker or to raise awareness, this is something to think about. So let's go ahead and jump in. What is an AI? Well, you know, people call it machine learning, a machine that appears to think. If you actually dig into it, it's all probability, mathematics, and software. Okay, I did my first AI project I was in college, it was around 1988, and we were asked to identify a circle, a triangle, or a square. That's how basic it was when I was coming up. Okay, now it's gone a lot farther than that. And the way you typically the way you create an AI is you start with data, and the quality and the volume of the data is very important. This is why these companies fight over data so much. There was actually a company that was going out and buying data for failed clinical trials of a drug. Why would they want data on failed clinical trials of a drug? Because it's data. They want more data. So this is, you know, this is why all the companies are giving stuff away for free, because they get your data. They know where you are, they know what you do, they know what you like. So the data is very important to build the AI. Then you train the model. You know, you're not done after you're training the model. You have to actually see if it works. So you test the model, you validate it, and then use that model on new data to make a new prediction, right? So that's that simple. So for example, on facial recognition, you would train the model using faces, and then you would validate the model, and then you would give it a face, and it will give you an answer, right? It's not always right. Sometimes it's wrong, okay? Sometimes it's wrong in different ways, right? It might not identify somebody's face who's in the database, or it might identify somebody's face who's in the database, but it isn't the right face, right? So there's a whole bunch of data science stuff that you can get into with AIs. Then we get into ChatGPT. So these are generative pre-trained transformers. These things, you could give a whole presentation on these, right? You can spend your whole day talking about ChatGPTs, right? If I could have the whole presentation generated by a ChatGPT if I wanted to, and I could have the thing say it, I'll just sit down and press a button and let it talk. But it's based, again, on mathematics and probabilities, all right? And the funny thing is, we don't exactly know how these things work. But once you give them billions of parameters, it starts to spit out stuff that starts to look like a person. It's really kind of crazy. So here's what I did. This morning, I asked ChatGPT to write a 4-line poem on the AMA. And here's what it said. In Ahmedabad's vibrant heart, very clever, where knowledge takes its stand, the Management Association thrives, a guiding hand. Leadership cultivated, wisdom sown, in AMA's halls, success is known. Isn't that crazy? Okay? But here's another thing that I asked this. I was helping my daughter with her physics homework, and she talked about dropping balls. I said, wait, I don't think that's right. So I asked ChatGPT, I said, if I drop a heavy ball and a light ball, which hits the ground first? And it said the most ridiculous thing. Here's what it said. The ball that is heavier will reach the ground first, okay? This is due to the effect of gravity, which causes heavier objects to accelerate faster than lighter objects when dropped from the same height. This principle was famously demonstrated by Galileo, and I remembered this part, right? Who showed that in the absence of air resistance, all objects fall at the same rate, regardless of their mass. So it's contradicting itself, and it's wrong. So I actually found a video of a guy on the moon. He was on the moon, he had a hammer, and he had a feather, and he dropped them. They hit at the same time, okay? This is physics, right? If you use your head, you won't figure it out. You have to do the experiment, okay? So, what did I do? Okay, so it's wrong, okay? So this is just something to consider. This is sort of just like a little, amusing part of the presentation. But it's really something to consider in your law practice or whatever field you go into. Be careful with the ChatGPTs. It might not be right. It'll write an eloquent book report for you, but it'll make up characters in the book, right? So just be careful. So looking at artificial intelligence cases, this is the number of AI patent applications. As you can expect, it's gone way up, and I'm sure now it's up here somewhere, right? So that's where we're at. They keep increasing. The discussion is there. It's been for a while. This actually goes all the way back to 2018, which seems like the before times, right? I mean, that's way back. It's only 6 years, but and they were already talking about it in Europe. So Europe is very serious about this. They want to know what you can patent and what you can't patent. Very mature. The U.S. is kind of getting to it a little later in the game, and I don't know. I haven't researched India, but India will probably, if they haven't already, have some policy initiative on this. And so that's what we're talking about today. Now, we're not, unfortunately, if you want to ask these questions, I will answer them. This is not so much about how to draft a patent or how to, whether or not you can get a CRI on some particular software. We can talk about that if you'd like. But what I'm talking about today is just patent infringement. And so, just very quickly, a patent is a government monopoly. After 17 years, well, it's really 20 plus, and it gets complicated anyway. The whole idea of the patent system is that it's an elaborate gifting system that will allow technologies to pass into the public domain, but it takes about 20 years. But anyway, so infringement is if someone makes, uses, or sells the technology, that's an infringement. So make is pretty easy to understand, right? You put together something that infringes the patent. Use is a little interesting because I didn't make this, somebody gives it to me, I use it. If it infringes the patent, then I am a patent infringer because I'm using it. Sell, you can see why that would be interesting because these things come across the border, they can be sold in stores or what have you. That would be the other. The other thing is importation. There are special rules on importation that I'm not going to cover here, but that's about it. So what? Well, if you infringe, then there are legal remedies. You can go to court, you can get damages, which essentially means rupees, or you can get an injunction. In other words, stop selling, stop making, stop using. The court can say you have to stop. And seizure, where they actually will take the goods. Right? They will put them and just take them away, and that can happen. All right. Now the special considerations. Whenever we talk about infringement, this is interesting. You might if you kind of think of yourself as okay, my job is to catch infringers. You have a couple things that you need to look at. One is policeability. Let's say I have a patent on the inner workings of a computer. How do I know if anyone's infringing? You can't tell, right? Because it's inside the computer. Particularly if it's in the cloud. It'd be very difficult to tell. This is what we call policeability and detectability. So if you are in the software patents and you are drafting a patent claim and you are trying to figure out the best claim, you want a claim that you can tell. You can police. You can detect the infringement. There's validity. So you may have the patent, and the patent office may have granted the patent to you, but it might not be valid. There might actually be some reason that the patent is not valid. It's indefinite. There's some other prior art that the examiner missed, whatever. It might expire, what have you. And then you have the remedy. So then you pick which one you want. Do you want money? Do you want to stop? Do you want to seize the goods? These are the things. And then there are ethical considerations that we'll look at. So let's go through this pretty quickly. I'd like to leave some time at the end for questions. As I was saying, if AI is a black box, and how do I know if it's infringing or not? Say I have a claim to training the AI, and I pull out my Siri, and I operate Siri. Hi, Siri, what's the temperature? I have no way of knowing how that was trained, right? Because I'm not in Apple watching them train it. So that's something to think about. The improvement may be in the way it's trained. Can you tell how it's trained by looking at it? Are the methods of training documented, right? So under U.S. law, I could subpoena Apple and tell them, how did you train this? And then they would have to tell me, but I'd have to get into court first, right? Can I get full access to the model and tell how it behaves? In other words, can I figure out how it was trained by asking it 50 questions, and then I can find out, well, actually, it must have been trained on this data, otherwise it wouldn't have been able to give those answers. And you can also place Easter eggs in your model, right? And that's more of a copyright thing. So has anybody ever asked, you know, hey Siri, will you marry me? And it'll say something like, well, the Supreme Court might have something to say about that. Okay, that's sort of an Easter egg, right? It's like a little thing. I think if you say, hey Siri, tell me about Steve Jobs, it'll pop up and say, we have created a memorial for Steve Jobs. Go click here and you can read more about his life. That's like an Easter egg, right? Because that's not telling me about Steve Jobs. That's something that they put in there. So if you copied this, right, and it says exactly the same thing, then you know it's been copied, because, and so that's a copyright thing. All right. Can copyright pollute an AI? Well, we'll skip over this, but it's just essentially, you know, can an AI sort of absorb copyrighted information and become an infringer, right? And then validity is a separate issue. It's a common way to attack it. And then damages and injunction. Let's go straight into ethical considerations. What if an AI provides for the safety of people? So now we have an infringement scenario, but the AI is safety-based. So here we go. Put on your ethics hat. We're going to go into this, all right? What if there were an evil AI? Could there be a virtual unclean hands? Could an AI be equitably stopped for taking you know, a reckless action? I mean, I don't know. But let's do this case study then. So there's a company called Oil Well and Company that develops an AI with data that directs where oil wells should be drilled. Okay, it says here, drill the oil well here. It tells you, the AI. You give it the map, it tells you where to drill. In addition to having this 90% success rate, it avoids drilling where oil would leak into groundwater. So this might be a great place to drill, but if you drill there, then the oil leaks into the groundwater and poisons villages downstream, okay? So it's been very successful, right? And another company starts taking business from them, and they sue them for patent infringement. Hey, I think they're copying our stuff. And you'd have to get a lawyer and figure out how to do that. Do you have enough evidence? But say you have enough evidence, and you put together and you file the lawsuit. So the question is, on what basis could the lawsuit be filed? Let's say an employee leaves and says, yeah, they're copying your stuff. That would probably be enough, right? Because now you have evidence that they stole from you, okay? So then after the suit is filed, it actually discovered that they developed their own AI. So the employee was lying. It was independently developed. It wasn't infringing. So how do I develop infringement, okay? So these are the things that can happen. And, well, we'll skip over this. So then if there is infringement, what are the damages? And how do I enforce an injunction? In other words, the damages might be stopped using the AI. Well, how do I know if they stopped or not, right? And then now they continue doing business. The other company wanted to try to use that patented thing, but they couldn't. And they had to develop their own. And guess what happens? They drill a well, and it causes leakage into the groundwater, and it poisons downstream. Now we have a problem, right? Contaminating water for thousands of residents. Who pays? So now the state steps in and says, wait a second. We don't want this happening anymore. We don't care about the patent law. We don't want there to be drilling in these, so you have to provide access to this. How would you do that? I don't know. You could have, I've heard some people talking about compulsory licensing. Compulsory licensing could be one way maybe to solve something like that, right? You say, okay, you invented this, that's great, but you can't lock it up in a drawer. You have to let people use it, and you have to provide a license. So that's it, that's really. So it's important to understand these issues so proper legislation and policies can be implemented. That's it. I don't really have a big, long, drawn-out presentation on software patents, but I do have this. And this is 2 people in our office who are drafting patent applications in the field we just talked about. One of them is Ryan Heck, and he does deep dives into ChatGPT. He always has the latest premium version. He's one of these guys that has to always be up to date. If you talk to him, he's going to start talking to you about ChatGPT. He just loves this thing, right? And he actually drafts part of his patent applications using ChatGPT. One of the things he does is he will ask it for alternatives. So he'll say, what's an alternative? A screw and a nail and a pin. Give me 5 alternatives. And ChatGPT will give him 5 alternatives that he can then put in the patent applications. But he has to filter out mistakes because everything that ChatGPT generates, oh, thank you, appreciate that, that'd be good. Because everything that ChatGPT generates could be a mistake. We just saw that, right? So you just never know. But he observes how people who read his patent applications compliment him on his eloquence, because he's not writing it. ChatGPT is writing it. So he oftentimes, like any good lawyer, you know, he's thinking about what he's doing. The first parts of the patent application he writes using ChatGPT, so that people look at it and say, wow, this is really, really good. And then he drafts by hand the rest of it, maybe a section or two. He says, if I have a difficult paragraph, I'll feed it into ChatGPT and ask it to rewrite it for me, and it'll do that. So it's his work, but it's rewriting it for him. And then, of course, he has to edit it for style. He doesn't want the ChatGPT to sound like Shakespeare or something like that, right? He has to go in and actually make it match the style. But he actually uses it on a regular basis. And one of the things we did in our office is we took an old expired invention, and we took the information that the client gave us, and we fed it into ChatGPT and asked it to generate the patent application. And it didn't do a very good job at first. But there's this thing called chain of thought prompting. You've heard of this. So the chain of thought prompting is that if you ask it a question and expect it to get the answer right away, it doesn't do so well. But if you start here and you lead it to the answer, it does a pretty good job. So what we do is we'll say, here is the background of the invention. Here's a description of a problem that was presented. Here's how the invention solves the problem. And here is a working example. Here are some of the benefits. Now, draft me a 3-paragraph description from the point of view of a software developer using technical language describing the invention. And it does a pretty good job of that. And then you can say, draft me a patent claim. And at that point, it does a pretty good job. And you might even look at it and say, no, I don't like that. Could you change this part in the claim? Or draft your own claims and put them in. Here are some claims. And then say, draft me a patent application. At that point, it does a pretty good job, right? Because you've set it up. So that we say that it drafts about the same as a first year working at a law firm, which is, you know, it's not the best, but some people are filing like that, right? There are people who are filing these. Now, the big caveat is that you can't put confidential information into the ChatGPT because it's going outside, right? You don't know what they're doing with that. Now, there are private GPTs. There's a Bing chat that you can use. If you pay a subscription fee, they will make sure that it stays private. It's not as good, I don't think. But you can use that one. So that's the type of stuff that people are doing out there with the GPTs. Then Jay has studied the internals of these LLMs. So these LLMs are actually quite complicated. They're transformers, probabilities that are going on. There's all these things, and he's sort of mapped that stuff out. He wrote our boilerplate. In other words, he put together a general description of how a ChatGPT works. And as it turns out, there are lots of different kinds of LLMs. They aren't just used for transformers. That's not the only thing they do. And there's alternatives to ChatGPT. Like I just said, there's a Bing chat. There's also a BERT. There's some others that are out there. So if you wanted to draft one of these applications, you have to have all that information. You have to put that in there. Because you don't want to get a patent on a ChatGPT. You want to get a patent on, you know, a large language model, a generative large language model or something like that. So that's what I have for the artificial intelligence and the infringement topics. But I'm certainly happy to take any questions, or I can actually, how much time do we have? We have enough time. Picture's worth 1,000 words. This is an actual AI patent. Yeah. Can you read that? Yeah, I think you can. 23andMe, who knows what that is, right? That's the company associated with Google that will sequence your genome. You spit in a tube and you send it to them. They sequence your genome. And then they tell you stuff. You must have a long-lost Icelandic cousin, right? Because they can figure out that your genetic history. And they can also figure out whether or not you're predisposed to certain diseases, which is very important because you might have sickle cell anemia you would not know, right? So this patent it's actually somewhat old, right? 3 years ago. These folks, I would say they're a little ahead of the curve, right? So they're doing very well. And it is issued. Now let's take a look at what it's about. That's a long abstract. That's a very long abstract. Predicting the phenotype from genetic information. Now the phenotype, so the genotype is the genetic sequence, the phenotype is what you actually see. So blue eyes would be the phenotype. Or, sickle cell anemia, I guess, could be a phenotype because it's something that's expressed physically. So then let's look at this. First thing I notice is this is the list of references that the applicant provided during prosecution, except for the starred ones, and there's only a handful of starred ones. This is what the applicant provided. That's 1 page, 2 pages. This is outrageous. 3 pages. This is a ridiculous number of references that they cited to the Patent Office. Now, can someone tell me why they did that? Why would they cite 400 references to the Patent Office? Because they think they're going to be going to litigation. All right? They actually probably are going to sue somebody on this patent. So if they sue somebody and somebody says, oh, here's some prior art, they'll say, well, I think it's in that list somewhere, right? So it's going to be hard for somebody to challenge the patent with something new because everything that's ever been done is listed. So it's not going to be a question as to whether or not they're entitled to the patent. It's going to be a question of whether or not you infringe. So that's what they're trying to scare people. This is a scare tactic, right? They're trying to scare people. And it would work. I mean, if I were sued with that thing, I'd run the other way. So this is sort of what I call like the 50,000-foot view. And these are good to have in a patent application so that we can look at it and in 60 seconds we can figure out what the patent is about. So this is going to be the customer probably, I'm going to guess. These are the people from the past. So it's sequenced, 20,000 people. It's more than this, right? It's probably like 20,000, 100,000 people, whatever, that goes in here and they're members. And then they generate a model that generates, the model generator generates the model, and then it takes their information and feeds into this, which then predicts the phenotype, okay? These are good to have in an application because you can show it to the inventor too, and the inventor might say, well, actually that's not right, this information comes in. It's like a data flow diagram. I call it a 50,000-foot view, whatever you want to call it. Now from a patentability standpoint, this could be a problem. It's just mere presentation of information. You need something more than that probably. But we'll see. They got the patent. And then here's a very simple boilerplate. That's just a computer, right? That's all that is. Then we have this very simple, this is their method. Brilliant, just 3 steps. You should always have a flow chart, by the way. You really can't file a patent application in the software space without a flow chart. It just doesn't make any sense. Inventors don't like flow charts. It doesn't matter. This is sort of the the data that's in there, right? It's sort of like a table or a database. And this is a slightly more complicated flowchart. It's kind of sloppy, actually. They didn't do a very good job on that part there. And then here's the patent application. This is what they look like. And you're talking about DNA and all this stuff. And it's not very long, actually. I'm quite surprised. Boom, boom. And that's it. And here's the claim that they were able to get. And this thing's going to be a little touchy, but I think I can get it to come up. Yeah, there we go. There we go. So the claim, and never try to read patent claims on a screen like this, but this is what we're going to do. Okay, so to tell if someone infringes, you go through this with your little clipboard, and if the infringer has it, it's a check. Okay? So a network-based computer system comprising one or more processors and one or more memories, wherein the one or more processors are configured to, everybody does that. That's just a computer, so check. The next thing is retrieve genetic information and additional information, their name, of a plurality of members of a personal genetic service, 23andMe, from the one or more memories wherein the additional information of what it comprises environmental information and phenotypic, I guess it is information, no, it's phenotype, isn't it? Phenotype, I don't know. Phenotype of interest, and wherein the additional information of the plurality of members was received over a computer network. Well, it's all going to be received that way. So this is the first part of collecting the information. Remember, be trained, you have to collect a lot of data, right? So this is collecting the data. So you set up a service and you ask everybody to participate, and then you collect all their data. Then you train a machine learning model by fitting one or more models to the genetic information and additional information of the plurality members, wherein each of them, one of the models is configured to receive as a model. Okay, configured to receive as model input genetic information and environment information, and provide a prediction of the individual having or developing the phenotype. Having or developing the phenotype of interest. This is actually a hugely broad claim because it's essentially saying getting data, training it, and then based on someone's genetic information, predicting whether or not they have blue eyes or a disease or whatever it might be. And this issued out of the US Patent and Trademark Office. All right, this is a real patent, and it has a lot of references cited. So it kind of gives you an idea of what's out there. The other reason I say that this is probably setting up for litigation is look how many claims it has. Oh boy. Yes, it has 28 claims. So they paid extra for that. You only get 20 free claims in the US. And notice also that they have all systems in only one method. Why have any method? Well, I don't know what it is in India, but in the United States you have to mark. And if you don't mark, you can't get damages. All right, so you have to say on the thing that you know, covered by U.S. patent, blah, blah, blah. Except how do you mark a method? Well, the United States courts have decided you can't mark a method, so you don't have to. And that's actually kind of silly because these days you could probably mark it, or you could just put a notice on your website or whatever, but that's the law. So you want to have at least one method claim so that you can go back in time and get damages from when you didn't mark. So that's probably why that was put in there. And then this is called a computer program product claim, and that's essentially a claim that would cover. Remember, we said make, use, or sell. If the software program is on this, then selling this would be an infringement, even though the method isn't really actively being created or being executed. It's a computer program product having stored there instructions that, when executed, cause the computer to do something. So that would technically cover this. Except that this isn't doing any training in this case, right? So this is definitely not infringing because it's not training. So their issues on infringement would be they have to prove that somebody trained. But how hard is it going to be to show that somebody trained when it's this general, right? If somebody's doing a prediction, they must have trained. So, you know, this is very well written, very broad. I would say, you know, 23andMe seems like they have a pretty powerful IP portfolio based on this one. We don't represent them. In fact, we don't represent Google or any of those because we represent Microsoft and Amazon. So we're on the other side. So that's it. So that's what I have for my presentation. I, of course, encourage you to come up with any questions you might have. We can talk about AI patents. We can talk about software patents in general. We can talk about trademark. We can talk about trade secret, whatever you like. So thank you for your attention.
So thank you, Greg. It was a very informative session. I'm sure the audience has gained a lot of stuffs and there's something to take back home. Now I invite Mr. Pranav Pandya to give vote of thanks.
Good evening. I know we have got a long weekend ahead and a very nice one too, a celebratory weekend, Uttarayan. And therefore, I thank all of you being there evening today. In India, by the way, Greg, now we also have a saying among the tech ecosystem, thank God it's Friday. So we have started enjoying Friday evening. And therefore, I'm really thanking you guys that you could make it. Just on a jokingly, while you were talking, I was feeling kind of reinvented. So do we have patent of getting reinvented or not? I don't know that. So you can just think about that. Food for thought. But yes, as far as AI and Gen AI is concerned, I just wanted to feed in something. I just spoke about it as a Geisha IT Association chairman in one of the panel discussion at Vibrant Gujarat, that Gen AI can be termed as creative AI, and the traditional AI is always there. It was always there since 1952. Arvind Bhai would always agree that traditional AI, which we used to call as IKBS, Intelligent Knowledge Based System. Greg, another point as an extension to what you said, what we have realized in the tech ecosystem is that if Gen AI works on the output of the traditional AI, then it is pretty regulated and it is pretty okay to use. And as you rightly said, it needs that kneading and godding to come up with an appropriate answer. And therefore, traditional AI's output as input to Gen AI is the way to go. Thank you. Have a nice weekend ahead and enjoy. Bye-bye.